All right, peace and blessings. David Hinkson is producing an incredible amount of material and content from prison. Today he wrote a letter to the Bundys, and we're going to read it. This letter is also on his webpage on Year of Jubilee with 1E. So if you want to download the letter from there and read it, you're welcome to. If not, stick around. I have been following your story in the Wall Street Journal. I was the paralegal that did the legal briefs working with George Grizzotti back in the early 1990s. We won the Sagebrush Rebellion number 2 at that time, as we made an argument against them that made them shriek in terror. You are now doing the Sagebrush Rebellion number 3, and I wish you all the luck in the world. I would like you to win and drive these people to finally leave you alone, as this is your God-given right. The problem is that even if you win, they will wait a few years, and when the next group of ranchers do not understand the real truth, they will again attack. You must stay vigilant and accept and teach the real truth and true concepts. You were the only rancher that fought, and the others all caved. Now you need to teach the others and have them join you and take back your lands from the BLM. You do not and should not have to pay any rental fees, as the BLM does not own this land. I have all the arguments that you need to use right here in my mind, and now I would like to express some of them here to you in the next few emails. You can use this email as a guide if you would like to create your own legal brief. I would just send the winning brief as I had it on my computer, but I've now been a political prisoner for 16 years. If I help you, I expect you to keep the fight going and teach others and be a beacon of truth in this matter, as this is not a game and is serious business. As I read through the archives at University of Las Vegas going all the way back to 1776, I learned that all of the land claimed before the Civil War was in fact claimed and owned in a different way than it is held today, as these lands were all called unappropriated lands before the Civil War. And to maintain proof of your ongoing ownership, you would use a folder that showed up who had sold the land to who after it was claimed, and this concept is called an abstract of title. All of the land rights were protected in the Republic under the venue known as common law, not statute law. That is counter-distinctive to common law. There is no crime and no claim against you in the common law unless there is an injured party. There can only be an injured party if they have a predecessor who claimed your lands before you or your people did. But here is how they have scammed you/us, is that now they have even renamed our lands to be referred to as public lands after the Civil War. Therefore, you are not using public lands, and you are in fact using your private property that was claimed from the unappropriated lands before the Civil War. This means you own these lands. Even banks used to loan money to ranchers as they really were the owners of this land. The BLM now tries to convert these ownership rights to being a right to rent these lands. They have no legal or even a constitutional right to do this. Even now, any citizen who is a citizen of the United States of America, Republic de jure, has the right to go out and claim any land that has never been claimed in the past by a de jure citizen of a republic. What this means is that since the Civil War, no citizen have claimed any lands using deed polls, and they have further failed to maintain their abstract of titles. What they now use is de facto title insurance, then try to remake our reality in every way possible to take away our rights to be real citizens in a real republic. For example, before the Civil War, the elected officials, i.e. sheriffs, had to go out and get a bond. Now they get an insurance policy from Risk Management de facto. In Nevada, the law plainly says, for instance, that if the newly elected sheriff does not get a bond within a few weeks of taking public office, he is no longer the elected sheriff. A de facto insurance policy is not a de jure bond. They will lose in court. As I have tested this theory out, everything has a new name after the Civil War, and it is all based on a construct fraud scheme. And there is no statutes of limitation on fraud, even in statute law. So what I'm trying to tell you is that even President Trump does not own his so-called Trump Towers as a citizen of the Republic. What this now means is that you could now go and file a deed poll on his property, and he will not be able to prove you do not own it. I filed a deed poll for a guy named Ron Allen. He had a mining claim over on Boulder Highway next to a casino. Then I sent a letter to the BLM and told them that if they did not like the fact that he had claimed this property worth about $30 million, they could go to court against us, and that we were going to demand a common law trial based on the 7th Amendment of the U.S. Constitution. Note here that there are two constitutions, as we now have the de facto after Civil War Constitution, called the U.S. Constitution, and the de jure Constitution of the United States for America. Just word games they play. But this did and does not matter, as Abe stole and plagiarized the entire text of the real Constitution and made it the corporate bylaws in his phony U.S. corporation. Do you think that voters are citizens? They are not. Do you think that a corporation can have citizens? They cannot. This is why you are now de facto citizens of a phony, unconstitutional corporation, like being a citizen of Burger King. Statute law is the law of corporations. Civil law are the laws of corporation. So civil rights are rights given to you by a corporation. Do you think that the founding fathers were so stupid as to not have bothered to put a citizenship clause in the Constitution? Why do you all think this? Do you think that you can only use a motion for all statutory pleadings, and that you can only use a writ for all common law pleadings? Did you know that every lawyer pledges pursuant to oath that to never use the common law in any courtroom? So it is the guarantee of writ of habeas corpus that guarantees your right to have common law in all criminal matters. Who is the injured party in your fight with the BLM? But what you have to realize now is that both of these so-called constitutions, de jure and de facto, each have their own version of the 7th Amendment to be found within. Therefore, it does not really matter which one you claim, as the federal government is in violation of both or either. With all of their illegal and unconstitutional ongoing activity, leaving in the correct verbiage had to be done to trick the people into thinking there had not been a change. When they created the new U.S. corporate constitution, of course nobody really wanted to join in this, so they offered the freed slaves their chance to be corporate citizens. So they think that they got away with the scheme, but now there is a new problem for them, as they really should not have left the 7th Amendment of the U.S. Constitution document. Note that they even still use the correct oath to swear when you join the armed forces or become elected. This makes everybody guilty of treason going in. Who is to complain? So in a case called the Erie Railroad versus Thompson, the de facto U.S. Supreme Court ruled that they have no common law venue period. They cannot go there. This is great, as now we can file a brief in their de facto corporate court and demand our constitutionally guaranteed rights pursuant to the common law. If they don't give it, it becomes a controversy that now exceeds $20, and they have now committed a civil rights crime pursuant to their own phony 14th Amendment. They have now painted themselves into a corner. They have to do it, but they cannot grant it. It is not my problem. I can remember when I did the legal briefs for the rancher Mr. Wayne Pearson, and we used the 7th Amendment. They surrendered and gave him coffee and donuts twice. I even was able to evoke the 7th Amendment in a courtroom in North Las Vegas. The prosecutor came up and said, "Mr. Rasakas, just give us $150 and we will call your ticket. We will call your ticket for not having insurance, a parking ticket." Johnny then said, "I want my common law jury trial as is guaranteed by the de facto U.S. Constitution." The prosecutor then said, "The U.S. Supreme Court has ruled that you don't get a jury trial for a misdemeanor." I then said, "Excuse me, I think you are talking about the case titled Blanton versus the City of North Las Vegas case, where the court stated that pursuant to the 6th Amendment, you don't get a jury trial for a misdemeanor." "Yes," he said. "I was the lawyer that took that case to the Supreme Court." I said, "Counselor, you did a really good job of not talking about the common law, as you have sworn an oath to never use it. But when you swore in front of the bar, you sworn an oath to never use it when you swore in front of the bar. Counselor, I have read your case, and you never mentioned the 7th Amendment, and that means that you have no stare decisis in this issue." He got very angry, and then the judge came in and whispered something into the judge's ear, and the judge started screaming for Johnny to get the hell out of his courtroom. In conclusion here, when you mention the 7th Amendment, they cannot answer or address you, period. Who are they afraid of? I will tell you. To go into the common law is an attack against God, and they know it. It violates Jesus, and they will be damned if they try to go there. Of course, the U.S. government will tell you that they can do whatever they want with the land that they own, and then they will quote the Wild and Scenic Borough Act. We had the fight, but my response back to them when we won is really great, but you do not own the unappropriated lands. It is the job of the country. It is the job of the country courthouses to keep track of who owns the so-called lands that are found within each county. If you check the record, you will find that the lands that the BLM claims to own are in fact listed under ownership name of the United States of America. This is the republic entity that Senny denied after the Civil War. What I'm attempting to tell you here is that they are not the United States of America. They are in fact the United States Corporation, but you don't have to believe me, as even their phony Constitution of the United States did not give or define them the right to own any of the lands within a state after the grant of statehood. Before the Civil War, when the pioneers went out and claimed the land, they used a doctrine that was referred to as best use or multiple use doctrine. Under this concept, if you needed to have 700,000 acres of land to equal a cattle ranch in the desert, see Valley Wells Ranch, to have enough available grass, you would claim it using a deed that was called a deed poll. So all land prior to the Civil War was claimed using these deed polls. These deed polls were filed in the land office, became the BLM, as they were assigned the task of keeping track of who filed on the claims first before statehood. Now, if someone found some gold on the land, they could also file as the first gold mine. Now, both owners have a right to use the land for the claimed purpose and exclude others. The right of exclusion is found in the 7th Amendment of the Constitution for the United States of America, de jure Constitution, which states in part that any controversy that exceeds $20, the right of a common law jury shall be preserved. So any citizen of the Republic could go out and find the land and claim it first, and the right was protected by the 10th Amendment under the separation of powers. The right to claim land was a right that reserved to the people who were citizens of the United States of America or a republic states. If you get the Law USC law books that were printed and check the thumb cases that are print in front of the public land section, you will find a case that states the following. All lands that are held by the federal government were only held for the sole purpose of creating new states, and to hold any of these lands after the grant of statehood, it violates the intent of the frames to create as many new states as possible. So as you can see, the framers never gave them the power or right to even claim or have claim to these lands after the grant of statehood. Note that nowhere in the Constitution for the United States of America did it give the newly created federal government the right to own any land in any state except for needful forts and dockyards. The Department of Interior was thus originally created for the sole purpose of being in charge of the dispensing of the unappropriated lands in the District of Columbia. Giving someone the right to be in charge who filed first does not convey ownership. In a republic, the claimant who files first in time is the owner unless someone else had filed a subsequent claim. Therefore, the BLM, as a sub-corporate entity directly underneath the Department of Interior, they are really just a management entity that was supposed to administer the lands for the District of Columbia, not inside of any so-called sovereign or republic state. Now, some will say that the state of Nevada gave these lands to the federal government during the grant of statehood. Yes, the new de facto U.S. government demanded that Nevada give up 88% of all of the lands that were found within her borders. Note that to make a state give up lands upon the grant of statehood violated the 10th Amendment under the separation of powers. In fact, the de facto U.S. Supreme Court ruled in a case called New York versus United States that for a state to give some privilege to the United States that is not defined in the Constitution would violate the separation of powers doctrine. Therefore, to make the state surrender 88% of her lands absolutely violates the 10th Amendment. Then we have another doctrine known as the equal footing doctrine, which reads in part that anything that is given to one state must be given to all states equally. Note that California nor Texas nor Kentucky gave up 1 acre, and to make a new so-called state give up 88% of her territory violates the spirit and intent of the Constitution, let alone the equal footing doctrine. What kind of statehood did they now give out? Before the Civil War, the Congress would meet at the de jure Congress of the United States of America, and after the Civil War, meet as a de facto Congress of the United States. Does constructive fraud mean anything to you? If you think that you can go out and hire a lawyer that has given a pledge to never use the common law at bar, don't waste your time. The problem is that this whole scheme of making and or creating new corporation that replaces the old republic is just a fraudulent scam that has been done over 100 times to cancel the common law. It is the New World Order scam. So when Adolf burned down the Reichstag and created a new company and called Germany Incorporated, he was canceling the republic and converting it into a corporatocracy. Now his citizenship had a demonocracy, not a republic. Remember the song by Spike Jones in 1938? It went fout to Hitler's New World Order. Then when George Bush raised his hand in a similar manner and said we must have the New World Order, are they the same? Mexico incorporated in 1941, but this transformation was much more peaceful. To grant Nevada statehood as a sub-corporate entity goes on to violate the sacred doctrine called equal footing, and it also violates the actual de facto and de jure constitutions, and it is still a fraud. First, I will state here that the state of Nevada is a sub-corporation that was created directly underneath and belonging to the United States Corporation. And who owns the U.S. corporation? I'm confused. This concept means that maybe the de facto United States really does own these so-called public lands within this so-called state of Nevada. But I don't think so, as here is their problem. They still are not the listed owner, and they have claimed ownership by default as they have canceled all the republic citizens. The listed owner is and always will be the de jure United States of America that was canceled by Abe. The reason that they cannot put it directly into their own name is that they have no constitutional authority, and either constitution have done so or to do such. So again, does it really matter anymore? What I'm now saying is that they do not even own Yellowstone National Park. Everything is now a fraud. So right now, we as citizens of a real republic that is venue in common law still have the right to go out and file a deed poll on these unappropriated lands. No such thing as public. You as the real owners of the property now and in the future can show that no claimant has ever filed a deed poll on any of these lands before you did. And I'm sure that you have your abstract of title ready to prove such. Therefore, if I was in your shoes, I would now go out and file a deed poll on every acre of their so-called public lands in the entire de facto state of Nevada that is now being administered by the BLM, as there has never been a prior claim by anyone that is still alive that is or has been a citizen of the de jure United States of America. Work with your fellow ranchers and take it all back. Work with the state legislature, and I will show you how to demand your equal footing rights. Then I would send the BLM a notice that says official notice and give them the standard 30 days to answer your legal presumptions. I would tell them that they have started this controversy and that has exceeded $20, and that you are thereby demanding the right to have a common law trial. They are afraid to give this to you, and they will not give this to you. Again, who and what are they afraid of? I know the answer, but you might not believe me. I would go into their statutory Babylonian county courthouse with my deed poll and record it there. They will warm them up to you. This will warm them up to you. When I helped seize the lands on the border highway in Nevada using a deed poll, I notified the BLM that they had 30 days to respond. They defaulted every step of the way, but in the end they got together with the Nevada Power Company and shut off the electrical energy. As it would seem, that is all they could do. We're back. Okay, boys, let's have a learning party. I'm a citizen of the Republic. I noticed that I could not get my deed poll filed in the county court recorder's office because they have created rules to make sure that I cannot use the rights of a republic. They said that I had to have an original signature on the original document, and this signature had to be notarized by their corporate officer. And of course they wanted to keep my original deed. As the holder in due course, legal term to scam you. And if you want a copy of your own deed, they will give you a certified copy. How nice they are. I want to keep my original, and I do not want to assign them or anyone else as my holder in due course, as I am and shall remain the holder in due course, and this is my business and not theirs. Their job is to provide the public recording that shows that I'm the owner and holder in due course. People are so trusting and ignorant. So I typed up my deed poll on a total of 2 pages. The first page was the common law page, and was the page that plainly stated that this document is a deed poll. That is filed under the right of common law and is to remain always venued in the common law. And I deeded myself the property in the name of Jesus Christ. and God as the giver and owner. I even signed the name Jesus Christ for him, as he did not show up for this special occasion. On the upper left side of the page, I printed instrument number 000001, as the paperwork is now going to be registered stock holding if I say so. I further stated, I, David Roland Hinkson, being a citizen of the Republic of Nevada, in the year of our Lord Jesus Christ, do hereby deed via this deed poll the following legal description. I use their legal description and their country to map to show that the land I claim, not a problem, as they did a good job surveying it for me. It is the survey in common law that proves ownership, say otherwise. They also will go ahead and charge you a transfer tax. Everybody thinks that this is a fee to transfer ownership to you. It is not, and that is why they affix their corporate seal on your original documents. This seal proves that they are going to be the holder in due course, but you have rebutted this concept, and now it does not matter. Just pay it and don't argue with them. They will also ask you what type of ownership you want, as in tenant in common or joint tenant. And of course, this does not matter either. Just tell them you are acting as a trustee, as you don't really like either of their offered renter choices. Filing or recording of this deed in no way creates an attorney in fact or a holder in due course, as the claimant is the same. Claimant has the original copy in his possession, as it is his business. Recording of this document was done strictly to provide public knowledge and to provide publicly that claimant is the true and correct owner of said lands in said below legal description. On this page I have all the signatures as copies, not original. I also show two witnesses that witness these signatures in the common law venue. The last or second page is the notary page. I, David Hinkson, recorded of this deed and in no way appoints an attorney in fact or a holder in due course. Now I have the same said signatures that were on the first page again and notarized on the second. This page is done so that when you give the deed to the county recorder, she will look at the last page to make sure she has your Babylonian notary seal and that these signatures are original, and now she records the document that undoes the scam. Then within a few days you can mail the registered letter telling them, the BLM and recorder's office, that this is your property and it has a value that exceeds $20, and if they have any problem with the type and consistency of your new type of ownership, they have 30 days to respond, or after that this matter will be considered settled, and if they are not happy about it, they can provide you with a jury trial pursuant to the 7th Amendment of the U.S. Constitution. Really, there is no such thing as the Republic of Nevada, as all of the republics were created before the Civil War. You really have no choice in this matter, for if you do not fix your land position, they will eventually take it back. You have but one choice at this time if you think that these lands belong to you. You must serve them and let them surrender or make a public spectacle out of it. One of the ways you might get some attention for your case is to go ahead and file a deed poll on some properties that you want to make an example out of. For instance, there is no way they can remove a common law anything, as again I tell you that they are afraid. This concept will also work for criminal part of your problem with the feds. I can send you another email telling you how I used the common law to get them to surrender. Note, one of the stories is about Wayne Pearson's son. We got all of the criminal courts removed using the 7th Amendment. The question now is, how much of this material do you want to use in your quest to get back your property rights? The common law is based on the teachings of Jesus Christ. If you fight for these rights, you will be fighting to bring back your rights under Jesus Christ. I look forward to hearing from you, and I would love to be of assistance to you and your efforts if you decide to demand your God-given rights. The words that I have typed in this email are 100% provable by me in all aspects. I stand ready to debate you if you want to have a friendly debate. With respect, your friend Dave. Blessings on you.